In 10 minutes, a county judge will read my parents' names aloud in probate court for draining the $450,000 trust fund my grandfather left for me and handing it to my cousin Jake. They thought it was a secret. They didn't know the trust had a clawback clause. And now, the law is about to force them to pay every single cent back. My name is Clara. My grandfather built that trust with his own hands to protect my future, not fund my cousin's aimless present. This is the story of how a single clause in a 50-page legal document became the trapdoor beneath my family's feet, and why, in probate court, blood is not thicker than ink. To understand how we got here, you need to go back to the last normal Sunday before everything shattered. It was the Sunday after Thanksgiving. The smell of my grandfather's pipe tobacco still lingered in his study, mixing with the scent of leftover pie. We were all there, my parents, my Aunt Linda and her son, my cousin Jake. I was 24, fresh out of grad school with a degree in architectural preservation, and sitting at the dining table with a stack of job applications. Jake, 29, was on the couch explaining for the 40th time why his latest venture, importing novelty phone cases, hadn't taken off. My mom refilled his glass. My dad nodded along. This was the hierarchy. I existed in the periphery, reliable, expected. Jake was the center, the perpetual project, the son my parents never had. My grandfather Arthur built his wealth from nothing. He owned a small chain of hardware stores in the Midwest, sold them in the late 90s for a little over $2 million. He was a man of quiet principle, who believed money was a tool for stability, not a ticket to laziness. He saw the writing on the wall with Jake early. He saw how my parents, especially my mother, could never say no to her sister's boy. So 3 years before he died, he created the Clara Marie Grantor Trust. It was irrevocable. Its sole purpose, spelled out in paragraph 4, section 2, was to provide for my graduate education and serve as a down payment on a first home. The trustees, my parents, the sole beneficiary, me, the amount, $450,000. He showed me the document once. He pointed a gnarled finger at a dense block of text on page 37. This here, he said, his voice gravelly. This is the clawback. If the trustees misdirect the assets, the court can yank every penny back from whoever received it. It's your shield, Clara, in case they ever forget whose money it is. He died in his sleep on a Tuesday in March. The grief was profound, but for me it was laced with a terrifying security. The trust was my bridge to a future. I had plans. A modest condo in a neighborhood with old oak trees. Stability. For Jake, Grandpa's death was just another event to monetize. He showed up to the funeral in a suit he'd clearly just bought, the tags tucked into the sleeve, and spent the reception complaining about the lack of an open bar. 2 weeks later, the first distribution was made, $10,000 from the trust, directly to my student loan servicer. I remember the email notification. I cried. It felt like my grandfather's hand on my shoulder from beyond the grave. This is where you need to understand the ecosystem of my family. My Aunt Linda is my mother's younger sister, widowed young, chronically overwhelmed. Jake was her miracle child, and his every stumble was a tragedy, his every minor effort a triumph. My mother absorbed this narrative. To her, helping Jake was a sacred duty, a way to support her struggling sister. My father, a mid-level accountant, just wanted peace. His philosophy was simple: the path of least resistance is the correct one. If writing a check to Jake made my mother and aunt stop talking, the checkbook came out. And Jake was a specialist in potential. There was always a scheme. A franchise, a cryptocurrency, a dropshipping business. Each one required seed money. Each one failed, without exception, leaving behind a trail of maxed-out credit cards and vague promises about lessons learned. He lived in a perpetually messy apartment my parents co-signed for, driving a car my dad helped lease. He was a black hole of need, and my parents were his steady, unquestioning event horizon. For 2 years, the trust operated as intended. It paid my rent while I completed an internship. It covered a certification course. Every quarter, I'd submit a formal request to my parents, as trustees, with invoices and explanations. They'd approve it, sometimes with a sigh about how complicated it was to transfer the funds. The money was doing what it was designed to do, building a responsible, independent life. Then, in the 3rd year, the requests started getting slower. A week of delay. Then 2. Then, in October, my request for funds to cover a security deposit on a perfect little apartment was met with silence for a full month. When I finally asked my mom about it over coffee, she wouldn't meet my eyes. The market's been volatile, sweetheart. The trust investments, we have to be careful, maybe next year. It felt off. The trust was in conservative bonds. There was no volatility, but I trusted them. They were my parents. They were the trustees. I tightened my budget, took on more freelance work, and waited. What I didn't know was that the volatility had a name, a face, and a new sports car. That same October, Jake had pitched my parents his surest thing yet, a luxury car detailing service for high-net-worth clients. He needed equipment, a branded van, insurance. The ask, $85,000. My parents, as trustees, did not have the authority to loan or give trust money to anyone but me for the specific purposes outlined. They knew this. But across their kitchen table, Jake painted a picture of finally being the success story, of making his mother proud, of being financially independent at last. He played the one card they could never refuse, the chance to fix him. So they wrote the check, not from their personal account, which was modest, but from the Clara Marie Grantor Trust. They called it an investment. In the ledger they half-heartedly kept, they listed it as an alternative asset acquisition. It was a lie. It was a breach of fiduciary duty so clear a first-year law student could spot it, and they did it believing no one would ever know. I was the compliant daughter. Grandpa was gone. The attorney was paid. They were in control. The first distribution was just the leak before the dam broke. 6 months later, Jake needed to cover payroll when a big client was late. Another $20,000. Then his car lease needed a buyout. $35,000. Each time the story was more desperate, the need more urgent. Each time my parents accessed the fund that bore my name. They were draining my future to fund his present, one emergency at a time, and with every transfer they grew more comfortable with the deception. They stopped mentioning the trust to me altogether. If I brought up my apartment fund, the conversation would swiftly pivot to how stressful and demanding Jake's new business was, how hard he was trying. I want to pause here. If you've ever been the reliable one, the one who follows the rules while someone else gets rewarded for breaking them, type "seen" in the comments. This pattern, it doesn't start with a grand theft. It starts with a small, justifiable compromise, a little loan, a temporary fix, but the architecture of betrayal is built one rationalization at a time. The turning point, the moment the entire facade cracked for me, arrived in the most mundane way possible, a piece of mail. It was a statement from the trust's financial institution, sent to my address by mistake, a clerical error that changed everything. I opened it, expecting to see the familiar record of my educational expenses. Instead, I saw a ledger of devastation. Disbursement to Jacob Martin, $85,000. Disbursement to Jacob Martin, $20,000. Disbursement to Jacob Martin, $35,000. A total of $187,000 gone. The current balance was a little over half of what it should have been. My hands went cold. The paper shook. This wasn't volatility. This was theft. I drove to my parents' house that night, the statement crumpled in my fist. They were in the living room, watching television. The scene was so normal it made me dizzy. I held the paper out. "What is this?" My father's face went pale. My mother's hand flew to her mouth. "Clara, it's not what it looks like," she began. "Jake's business, it was an investment for the trust. He's going to pay it back with interest." I asked to see the investment agreement, the terms, the collateral. There was only silence. Then my father's voice, firm with a false authority. "We are the trustees. We made a judgment call. It's for the good of the family. Jake is family." That word, family, it was the blanket they used to smother every objection. I told them they had violated the trust, that they had stolen from me. My mother started crying. "How can you say that? After everything we've done for you, Jake needed help. Are you really so selfish?" The conversation spiraled into a blur of accusations and tears. They were not apologetic. They were defensive. They were angry at me for discovering their secret. I left that night with the hollow understanding that my parents had chosen. They had chosen Jake. The next morning, I did what my grandfather would have done. I consulted a lawyer. Her name was Anya Sharma, a specialist in fiduciary litigation. I showed her the trust document and the statements. She read them in her quiet, sunlit office, her expression growing graver by the minute. She finally looked up. "Clara," she said, "this is as clear a case of misappropriation as I've ever seen. They had one job, to protect your interests. They failed. Spectacularly." She explained the clawback clause. She explained that we could petition the probate court to surcharge my parents, to hold them personally liable to repay every cent to the trust. She also explained that we could name Jake as a respondent, to claw the money back directly from him. But, she said, leaning forward, you need to understand what you're starting. This is a lawsuit against your parents. There is no going back from this. I sat in my car outside her office for an hour. I thought about my grandfather's face, the pride in his eyes when I told him I got into grad school. I thought about the condo I wouldn't buy, the stability I wouldn't have. I thought about Jake, probably detailing his new car with my money. Then I thought about the word trust. It wasn't just a financial vehicle. It was a promise, and my parents had shattered it. I called Anya back. File the petition, I said. My voice didn't shake. What happens now? She replied. Now we serve them. And then, in about 60 days, we all stand in front of a probate judge who will read their names into the record and ask them to explain why they shouldn't be personally bankrupted by their own decisions. I hung up. The die was cast. The gears of the law had begun to turn, slowly, inexorably, toward that courtroom. And I had no idea that Jake, panicking and cornered, was about to make a move that would turn a family feud into a legal war. The petition landed like a grenade in my parents' mailbox on a Tuesday morning. By noon, my phone was a war zone of missed calls and text avalanches. My mother's messages were tears translated into text. How could you do this to us? My father's were cold, legalistic bluster. Withdraw this immediately. You're destroying this family. I didn't answer. Anya's advice was clear. No contact. Every word can be used against you. Let the process speak. But Jake didn't believe in process. He believed in chaos. His first move wasn't through a lawyer. It was through my front door. 2 days after being served, he showed up at my apartment pounding on the wood. I saw him through the peephole, his face flushed, that entitled fury twisting his features. Open the door, Clara. We need to talk about this. You're making a huge mistake. I stayed silent, my back against the wall, heart hammering. He kicked the door once, a solid thud that shook the frame. It's just money, you'll get it back. You're so selfish. He finally left after 20 minutes, but the violation lingered. The safe space I'd built was breached. I called Anya, my voice shaky. He came to my home. Her tone turned to steel. That's harassment. We document it. We add it to the file. This is how bullies operate when the rules finally apply to them. The formal legal responses began a week later. My parents hired an attorney, a man named Robert Gable, who specialized in making messy family disputes look like simple misunderstandings. His response to the court was a masterpiece of deflection. Yes, distributions were made to Jacob Martin. These were not misappropriations, but prudent investments made with the future growth of the trust corpus in mind. He attached a single, hastily typed page purporting to be a business plan for Martin Auto Detailing, valuing it at $300,000. It was fiction. There were no client contracts, no profit and loss statements, just a description of a service and a wildly inflated number. Jake, however, was represented separately. His lawyer, a slick operator named Derek Finch, filed a response that was pure aggression. He claimed I had orally consented to the use of the funds for a family business venture. He said I was jealous of Jake's entrepreneurial spirit and was now using the court to punish him for his success. He even included an affidavit from my Aunt Linda, stating she believed Clara would have wanted to help her cousin. It was a wall of lies, but it was a wall. The battle lines were drawn. On one side, the truth and a 50-page trust document. On the other, a narrative of family unity shattered by a greedy, vindictive daughter. This is where the real cost began. Not the financial cost, the emotional one. The family group chat, once a stream of mundane updates, became a ghost town. Then, a week before Christmas, my Aunt Linda sent a single, blistering paragraph. It called me a heartless monster, accused me of trying to send my cousin to jail, and ended with the sentence that cut deepest. Your grandfather would be ashamed of you. I stared at those words. He wouldn't be. He'd be ashamed of them. But the doubt, that tiny, poisonous sliver, it found a crack. Was I the villain here? Anya saw me spiraling. She pushed a box of tissues across her conference table. Clara, listen to me. This is textbook. When enablers can't defend the action, they attack the person exposing it. They're trying to make you feel crazy for enforcing a boundary. Don't buy the ticket. She then showed me the next phase of her strategy, discovery. We were going to subpoena everything. Jake's bank records, his business licenses or lack thereof, his car lease agreement. My parents' trustee financial reports. We were going to turn over every stone and expose the rot in the light. They're betting you'll back down from the ugliness, Anya said. We're betting they can't survive the scrutiny. The scrutiny began with Jake's finances. The bank records arrived first. Anya spread the printouts across the table. It was a roadmap of my inheritance. The $85,000 business investment from the trust hit his account on a Friday. By the following Wednesday, $40,000 was transferred to a luxury car dealership, not for a detailing van, for a down payment on a 2-year-old BMW convertible. Another $20,000 went to pay off high-interest credit card debt, charges for restaurants, bars, and electronics. The payroll emergency, $15,000 went to a 3-week trip to Miami. There was no business. There was just Jake living large on my grandfather's legacy. Seeing it in black and white, the cold, hard numbers vaporized any lingering guilt. This wasn't a misguided investment. It was a shopping spree. Confronted with this in a deposition, Jake crumbled. He sat in a sterile conference room across from Anya with his lawyer frantically objecting. But under oath, the bravado melted. He couldn't name a single client for his detailing business. He couldn't produce a business license. He admitted the business plan was written the night before his own deposition. When Anya held up the bank statement showing the BMW payment, he shrugged. I needed reliable transportation for the business. It was pathetic. It was also a massive legal win. We had him. He had perjured himself in a dozen ways. But here, where the story pivots, where it went from a fight over money to something much darker. Jake, cornered and facing not just the clawback of the money but potential charges for perjury and fraud, made his masterstroke. He went to my parents, not with an apology but with a threat. I learned this from my father of all people. He called me one evening, his voice hollow, stripped of all its previous bluster. Clara, we need to talk, not as trustees, as your father. Against my better judgment, I agreed to meet in a public park in broad daylight. He looked 10 years older. Jake came over last night, he began, staring at his hands. He said if we don't convince you to drop the case, he's going to file a counterclaim. He says he's going to tell the court that we promised him the money, that we told him you didn't need it, that you'd agreed to it. He says he has texts. He says he'll drag us down with him. My father finally looked at me, his eyes terrified. He'll perjure himself again, and he'll make us look like co-conspirators. Our lawyer says it could expose us to more than just repaying the trust. Fines, even worse. The audacity was breathtaking. Jake was now blackmailing my parents to pressure me to abandon my own lawsuit. He was using their fear of legal consequences to force them to become his agents. The victims were being weaponized against the beneficiary. The moral universe of my family had fully inverted. I told my father everything then. I showed him on my phone the bank records Anya had compiled, the BMW, the Miami trip, the credit card debt. I watched the last vestiges of his denial die in his face. He played us, my father whispered, not a question, a horrified realization. All this time, he was just spending it. I didn't offer comfort. I simply said, the only way out is through. You have to tell your lawyer the truth, all of it, or he will destroy you to save himself. My father left that park a broken man, but a man finally seeing the battlefield clearly. My mother, however, was a harder sell. When my father told her about Jake's threat, she didn't turn on Jake. She turned on me. This is your fault, she screamed at me over the phone. If you hadn't been so greedy and filed this stupid lawsuit, none of this would be happening. Jake is scared. He's just reacting to you. The enabling ran that deep. It was a psychological fortress. I hung up. The bridge there was not just burned. It was ash carried away on the wind. Anya was furious when I told her about the blackmail attempt. That's witness intimidation. That's a whole new level. She immediately drafted a motion to bring Jake's conduct to the judge's attention. The case was no longer just about money. It was about the corruption of the entire fiduciary process. The court date, once a distant procedural step, now loomed with terrifying gravity. A week before the hearing, Anya called me with a new discovery. She subpoenaed the trust's checking account records from the bank itself, not just the statements. And she found something my parents had missed, something Jake had done in his panic. After the lawsuit was filed, but before the accounts were formally frozen by the court order, Jake had convinced my mother to make one last urgent distribution, $12,000, for legal fees to defend the family. My mother, in her panic and desire to make it all go away, had authorized it. The money was gone, wired to an account Jake controlled and immediately withdrawn as cash. This changed everything. This was a distribution made after the trustees knew the trust was under legal challenge. It was a blatant, knowing dissipation of assets. It was the nail in the coffin for my parents' defense of prudent investment. This was theft, pure and simple, and my mother had been the unwitting hand that delivered the final blow. I have to pause here. If you've ever seen someone you love be manipulated into hurting themselves, type "manipulated" in the comments. This is the insidious core of financial abuse. It doesn't look like a robber in a mask. It looks like a crying nephew, a desperate sister, a mother's guilt. The night before the first major court hearing, the one where the judge would consider our request for a preliminary injunction to freeze all remaining assets and formally add Jake as a party to the clawback, I couldn't sleep. I sat at my kitchen table with my grandfather's old Zippo lighter, flicking the flame on and off. I was no longer just Clara, the wronged granddaughter. I was a plaintiff. I was the reason my family would sit in a wood-paneled room and have their failures read into the public record. The wait was oceanic. Anya met me on the courthouse steps the next morning. The sky was a flat, grim gray. "Remember," she said, adjusting her suit jacket, "you are not on trial. The trust document is. Their actions are. Just watch." We walked through the metal detectors, down a marble hallway, and into probate courtroom 4, and there, already seated at the defendant's table, were my parents. They didn't look at me. Jake and his lawyer were at a separate table. He was wearing a cheap, too-tight suit, and he was sweating. The judge entered. The bailiff called the room to order. My case was called, in the matter of the Clara Marie Grantor Trust. The sound of my own name in that formal, somber space was jarring. Anya stood and began to speak, her voice calm and devastatingly clear. She outlined the facts, the terms of the trust, the distributions, the bank records showing the BMW, the vacation, the cash withdrawal. She presented it not as a family drama, but as a cold, clinical breach of contract and fiduciary duty. Then it was my parents' lawyer's turn. He stood, his arguments sounding feeble and hollow in the face of the evidence. He talked about family dynamics and good intentions. The judge, a woman in her 60s with sharp eyes behind her glasses, stopped him mid-sentence. "Counselor, I've read the trust instrument. I've seen the disbursements. Good intentions are not a defense to misappropriation. My question is not about intent. It's about liability. Who is going to make the trust whole?" The room held its breath, and that's when Jake's lawyer stood up. And he didn't argue about the money. He did something far more reckless. He attacked the trust itself. He claimed the trust was invalid, that my grandfather had been suffering from undue influence when he created it. I felt the air leave the room. Anya's hand shot up. "Objection, Your Honor. That is a new matter not raised in the pleadings. This is a blatant attempt to delay and confuse the issue." The judge peered over her glasses at Jake's lawyer, Derek Finch. "Mr. Finch, is this your client's new position, that the entire trust instrument is void?" Finch puffed out his chest. "We have reason to believe, Your Honor, that the settlor's mental state was compromised, and that the beneficiary may have exerted improper pressure to be named the sole recipient." He was looking directly at me. He was accusing me of manipulating my grandfather. The audacity was a physical blow. My grandfather was the sharpest, most stubborn man I'd ever known until the day he died. The idea that I, a 21-year-old college student at the time, could have influenced him into anything was laughable. It was also a nuclear option. If the trust was void, then the money would revert to his estate. And since my grandfather died without a will because he had a trust, the estate would be split evenly between his 2 children, my mother and my Aunt Linda. My mother's share would likely end up funding Jake anyway. It was a Hail Mary pass to make the entire lawsuit disappear and potentially hand Jake even more money. The judge was not amused. "Mr. Finch, you will file a formal motion to invalidate the trust by the end of this week with supporting evidence. Not speculation, evidence. Failure to do so will result in sanctions." She then turned back to the main issue. "For today, the injunction is granted. All remaining assets of the Clara Marie Grantor Trust are frozen, effective immediately. Furthermore, Jacob Martin is formally added as a necessary party to the clawback petition. He will file a formal financial accounting within 30 days. She banged her gavel. The first battle was over. We had frozen the assets and dragged Jake into the center of the ring. But the war had just expanded into terrifying new territory. In the hallway, my parents looked shell-shocked. Jake was whispering furiously to his lawyer. As I passed, he hissed at me, "You're gonna lose, you hear me? It's all gonna be mine." Anya steered me away. "He's desperate. Invalidating a trust is incredibly difficult. He has no evidence because there is none. This is just noise to run up your legal bills and scare you." But the noise had an effect. The local legal gossip mill started turning. A trust contest. is juicier than a simple misappropriation case. Reporters from the County Business Journal started calling Anya's office. My family's dirty laundry was threatening to become public spectacle. The pressure, which had been intense, became suffocating. Then the motion arrived. Finch's evidence of undue influence was a collection of lies so brazen it was almost impressive. There was an affidavit from a neighbor who claimed she saw me arguing with my grandfather in his garden a month before the trust was signed. About the weather, as I recalled. There was a statement from Jake saying my grandfather had told him he was confused about his finances in his final years. The centerpiece was a letter, allegedly from my grandfather to my Aunt Linda, expressing doubt about the trust. The handwriting was a poor forgery, the paper was all wrong, and it was dated 2 years after he died. It was so obviously fake it was insulting. Anya was incandescent. "This is fraud on the court. We're going to eviscerate them." She scheduled a special hearing on the motion to invalidate. This wasn't about the money anymore. This was about defending my grandfather's legacy and my own character against a slanderous, fraudulent attack. The night before that hearing, my mother called. She didn't yell. Her voice was a thin, broken thread. "Clara, Jake showed us the letter, the one from your grandfather. He said if we testify that Dad seemed confused, it would help settle everything. He said the court would just split the money and we could all move on." I closed my eyes. "Mom, the letter is a fake. It's dated after he died." "Are you really going to go into a courtroom and lie under oath about your own father's mind to help the man who stole from your daughter?" The silence stretched. Then, a soft sob. "I don't know what to believe anymore." She hung up. That was the moment I truly understood. The trust wasn't the only thing that had been broken. My mother's moral compass had been shattered. The hearing on the motion to invalidate was a legal slaughter. Anya was prepared. She had hired a forensic document examiner. He took the stand and in clear, simple terms explained why the letter was a forgery: the ink, the paper stock, the pen pressure, the anachronistic phrasing. It was a demolition. Then she called the neighbor. Under oath, the woman admitted she couldn't really hear the garden conversation, just raised voices, and that Jake had offered to pay her lawn service bill if she told what she knew. Finally, Anya called my parents to the stand, not as hostile witnesses, but as witnesses to the truth. My father went first. Anya asked him one simple question. "Mr. Grantor, in the last 5 years of your father's life, did you ever observe any sign of mental confusion or incapacity that would prevent him from understanding his financial affairs?" My father looked at Jake, who was glaring daggers at him. He looked at the judge. He swallowed. "No," he said, the word firm and clear. My father was sharp as a tack. To suggest otherwise is an insult. Jake slumped in his seat. Then it was my mother's turn. Anya approached the bench. "Mrs. Grantor, the letter entered into evidence by Mr. Martin claims your father had doubts about the trust he created for your daughter. Did your father ever express such doubts to you?" I held my breath. My mother twisted a tissue in her hands. She looked at me, her eyes swimming with a pain I couldn't fully decipher. Then she looked at Jake and her face hardened. "No," she said. "He never did. He was proud of that trust. He was proud of Clara. It was the first time she had publicly chosen me. It was a victory that tasted like ashes." The judge didn't even wait for closing arguments. She denied the motion to invalidate the trust from the bench, calling the attempt frivolous and supported by demonstrably fraudulent evidence. She then referred Derek Finch to the state bar for disciplinary action. Jake's nuclear option had blown up in his face, spectacularly, but the fallout was just beginning. Because now, with the trust firmly validated, we moved into the final, most brutal phase, the accounting. Jake was ordered to produce a full list of every asset he had purchased with the trust funds. The court-appointed forensic accountant we hired followed the money with the precision of a bloodhound. The BMW was located, the luxury watch he'd bought, the expensive gaming computer. It was all cataloged. The total value of the tangible assets, maybe $60,000. He had blown through over $120,000 in cash on living expenses, travel, and debt. The money was gone. The final hearing, the one to determine the surcharge, the personal liability of my parents, and the clawback from Jake was set. This was it. The judge would decide who had to pay back what and how. The tension in the weeks leading up to it was unbearable. My parents' lawyer was now negotiating frantically with Anya, trying to settle. They offered to sign over their retirement account to replenish the trust. They were finally, truly afraid. But Jake had one last card to play. He filed for bankruptcy. Chapter 7. He was claiming that the debt he owed to the trust, the $187,000, was just an unsecured loan, and he was wiping it clean. He thought he could walk away. He thought the law was a game he could quit when he was losing. Anya was ready for this, too. She filed an adversary proceeding in his bankruptcy case, arguing that the debt was not dischargeable. Why? Because it was the result of fraud, defalcation, or embezzlement. She submitted the entire court record, the fake letter, the false testimony, the bank records showing the conversion of trust assets for personal use. The bankruptcy trustee, reviewing the mountain of evidence, agreed. Jake's debt to the trust was declared non-dischargeable. The bankruptcy would wipe out his credit card bills, but it would not touch the judgment we were about to get. He was trapped. The morning of the final probate hearing dawned cold and clear. This was the day. The courtroom was packed. My parents were there, looking like ghosts. Jake was there with a new court-appointed lawyer, the slick Derek Finch having been fired after the bar referral. My Aunt Linda was in the back row, crying quietly. The judge took the bench and got straight to business. She summarized the case, her voice devoid of any emotion. She recited the facts: the trust terms, the fiduciary duty, the unauthorized distributions, the fraudulent attempt to invalidate the trust. Then she delivered her ruling. The court finds that trustees Gerald and Susan Grantor breached their fiduciary duty in a grossly negligent manner. They are hereby surcharged for the full amount misappropriated, $187,000, plus interest, and all attorney's fees incurred by the beneficiary in this action. They are personally liable for this amount. My father put his head in his hands. My mother stared straight ahead, unblinking. The judge continued. Regarding respondent Jacob Martin, the court finds he is unjustly enriched by the misappropriated funds. He is ordered to disgorge all assets traceable to the trust. The vehicle, the watch, the computer, and any remaining cash are to be turned over to the trust's successor trustee within 30 days. Furthermore, a monetary judgment is entered against him for the remaining balance, $127,000, which this court has already deemed non-dischargeable in bankruptcy. This judgment will follow him, with interest, until it is paid. Jake stood up. You can't do this. The bailiff stepped forward. The judge ignored him, addressing the room. This is a stark reminder. A trust is not a family piggy bank. It is a sacred fiduciary obligation. The law protects beneficiaries from exactly this kind of predation. Court is adjourned. The gavel fell. It was over. We had won. Completely, decisively. The clawback clause had worked exactly as my grandfather intended. As we walked out of the courtroom, Jake lunged toward my parents, his face a mask of rage. This is your fault, you stupid, stupid people. The bailiff restrained him. My parents flinched as if struck. They didn't look at him. They looked at me. On the courthouse steps, in the weak winter sun, they approached me. Anya hovered protectively nearby. My father spoke first, his voice ragged. Clara, we will repay the trust. Every penny. We'll liquidate the retirement account. We'll take out a loan if we have to. My mother just cried, repeating, I'm sorry, I'm sorry, I'm sorry. I looked at them, these two people who had chosen a lie over their own child. The anger was still there, a cold stone in my chest. But so was something else, a profound, weary pity. They weren't villains. They were weak people who had been manipulated by a predator, and in their weakness they had caused immense harm. The law had held them accountable. It had given me justice. But it couldn't give me back what was truly lost. I simply nodded. Your lawyer can speak to my lawyer about the repayment schedule. Then I turned and walked away with Anya. I didn't look back. The legal battle was won. But the real work, the work of figuring out if there was anything left to salvage from the wreckage of my family, that was just beginning, and it would be far harder than any court hearing. In the weeks that followed the judgment, the mechanics of justice ground forward with cold, impersonal efficiency. My parents' lawyer contacted Anya to arrange the repayment. They liquidated their entire $401,000 retirement account, the one they'd spent 30 years building. The funds were wired directly into the trust, now under the control of a court-appointed successor trustee, a stern-faced banker named Mr. Evans. With interest and my legal fees added, the total replenishment came to $423,000. The trust was made whole. My parents were left with their Social Security and the equity in their home. The financial safety net they'd woven for their old age was gone, unraveled by their own hands. Jake's disgorgement was messier. The BMW was repossessed by the trust's agent. I saw a photo of it being loaded onto a flatbed truck from the parking lot of his apartment complex. The watch, the computer, the few other trinkets were sold at auction. The total recovered from him was $68,000. The remaining judgment against him, $119,000 plus interest, remained on the books. A lien was placed on any future inheritance he might receive from his mother. His wages, if he ever held a steady job, could be garnished. He was not in jail, but he was in a financial cage of his own making. He moved back in with my Aunt Linda. The last I heard, he was working for a landscaping crew, paying cash under the table to avoid the garnishment. The golden boy was tarnished, living in his mother's basement at 31. My Aunt Linda never apologized to me. She simply withdrew from the family entirely. She blamed my parents for letting it get to court and blamed me for caring more about money than family. The enabling had turned to bitter resentment. She was alone with the monster she'd created, and that was perhaps the most fitting consequence of all. For my parents, the consequences were more than financial. The surcharge was a public legal declaration of their failure. The shame was a living thing in their house, but something else happened slowly, almost imperceptibly. The pressure of the lie was gone. The constant anxiety of covering for Jake, of managing his crises, of hiding their actions from me, it evaporated. In its place was a devastating, quiet clarity. They started the counseling the judge had strongly recommended. Not as a family with me, but as a couple. They had to understand how they got there. My father, in a series of stiff, awkward emails he began sending me every few weeks, relayed some of it. The therapist called their behavior financial enabling fueled by familial guilt and a pathological avoidance of conflict. My father wrote, "She said we sacrificed our daughter on the altar of our own comfort. It's a hard thing to read, but it's not wrong." He didn't ask for forgiveness in these emails. He just reported. It was his way of trying to be honest, maybe for the first time. My mother's journey was harder. She had a mini-stroke 2 months after the verdict. Stress-induced, the doctor said. I visited her in the hospital. She looked small in the bed, wires taped to her chest. When she saw me, she started to cry. Not the performative tears of before, but a deep, shuddering grief. "I am so sorry, Clara. Not because we lost the money, because I lost you. I chose a lie over my own child. I don't know if I can ever forgive myself." I held her hand. I didn't say it was okay, because it was, but I held her hand. That was the start. With the trust replenished and under new management, I finally accessed my inheritance. Mr. Evans, the successor trustee, was all business. He approved my request for a down payment with a swiftness that highlighted how abnormal my parents' obstruction had been. 6 months after the judgment, I closed on the condo. It was a 2-bedroom in a brick building with oak trees out front, just as I'd always imagined. The first night I spent there, on a mattress on the floor, I felt no triumphant joy. Just a profound, quiet safety. The door was mine, the locks were mine, no one could take it away. I used a small portion of the remaining funds to enroll in a woodworking course. My grandfather had loved woodworking. His old tools were in my storage unit. I wanted to build my own kitchen table, to make something solid and useful with my hands, to connect with him in a way that wasn't about money, but about craft. In the smell of sawdust, I found a piece the courtroom never gave me. A year to the day after the final hearing, my parents asked if they could see the condo. I said yes under 2 conditions. Jake would not be mentioned and they would not offer any opinions on my decor. They arrived on a Sunday afternoon bearing a houseplant. They were nervous, overly polite. They toured the space, my mother marveling at the light, my father nodding the solid construction. They didn't overstay. As they were leaving, my father handed me a manila envelope. "These are for you," he said. "We should have given them to you years ago." Inside were my grandfather's original sketches for the trust, drawn on a legal pad. In the margins were his notes. Next to the clawback clause, he had written in his tight script, "For Clara's protection, hope it's never needed." And on the last page, a note I'd never seen. "A trust is a promise. Money is just the paper it's written on. The real inheritance is the lesson, that some promises must be kept, even when it's hard, especially when it's hard." I cried then, for the first time in months. Not for what I'd lost, but for what he had tried so carefully to give me. My relationship with my parents now exists in a narrow, carefully demarcated space. We have monthly dinners. We talk about safe topics, the weather, their garden, my work. The deep wounds are still there, scarred over but tender. They know they are on probation, their access to my life a privilege they must earn daily through consistent, respectful behavior. They have not asked me for a single thing since the judgment. That in itself is a form of progress. The lawsuit did not bring my family back together. It did the opposite. It shattered the false unity that was built on my silence and Jake's exploitation. But in the rubble, something more honest has a chance to grow. It is small. It is fragile. It may not survive, but it is real. And Jake, the surprising detail, the one I learned only recently through the grapevine of mutual acquaintances, is this. The judgment against him didn't just sit there. The successor trustee, Mr. Evans, is a pit bull. He periodically checks for assets. He discovered Jake was named as a 50% beneficiary in my Aunt Linda's new life insurance policy, taken out after the trial. Mr. Evans filed a lien on that future benefit, too. Jake can't even profit from his mother's death without the trust getting its share first. The clawback clause, it turns out, has a long, long memory. So here I am, in my condo at the table I built with my grandfather's tools. The trust fund is intact, doing what it was meant to do, providing stability. The legal war is over. The family war has settled into an uneasy truce. I am not the daughter I was. I am not the victim I felt like. I am a woman who enforced a boundary written in ink 50 years ago by a man who loved her enough to foresee the storm. The law gave me justice, but it was the boundary itself, held firm, that gave me my life back. My grandfather's final lesson wasn't about trust law. It was about the courage to hold people accountable, even when they share your blood, especially when they share your blood. And that brings us to the end of the story. But before we go, I want to speak directly to you. If you're watching this and you see yourself in my story, maybe you're the reliable one, the quiet one, the one who follows the rules while chaos gets rewarded. Maybe you're holding a document you don't fully understand, or you sense a shift in a family dynamic that feels off but you can't quite name. I'm telling you this now, trust that feeling. Investigate. Ask the uncomfortable question. Read the fine print. What happened to me wasn't rare. It's estimated that trust disputes like mine cost beneficiaries $750 million in lost inheritances every single year. 40% of probate cases now involve some kind of trust litigation. The clauses are there for a reason. The no contest clauses, the successor trustee provisions, the clawbacks. They're not legal jargon. They are pre-written boundaries for when human judgment fails. My story isn't about winning a lawsuit. It's about a simple, painful choice. Do you allow the people you love to destroy what was meant to protect you, or do you enforce the boundary, even if it means they'll call you the villain? I chose the boundary. It cost me my family as I knew it, but it saved the future my grandfather envisioned. The law is not emotional. It doesn't care about Thanksgiving dinners or who was the favorite. It cares about documents, signatures, and fiduciary duty. In that coldness, I found my protection. In that rigidity, I found my freedom. So I'll leave you with this. Your peace is not worth less than someone else's chaos. Your future is not a bargaining chip for someone else's present. And a legal document, when used as the shield it was intended to be, can be more powerful than a lifetime of guilt trips and emotional blackmail. If this story resonated with you, if it made you think about a situation in your own life, leave a comment below. Tell me, what would you have done? Would you have filed the petition? And if you want to understand how to protect what's rightfully yours, the first step is knowledge. Hit the subscribe button below. I'll be sharing more stories like this, breaking down the legal realities behind family dramas and showing how the quiet ones can find their voice. Thank you for listening to my story. I'm Clara, and I am finally, unapologetically, the steward of my own future.